Welcome to Peachtree Injury Talk with attorney Jordan Jewkes.
Hello and welcome to Peachtree Injury Talk with Jordan Jewkes. Jordan strives to give injured victims a voice and provide strong advocacy against an often broken system. I am your host, Kevin Rosenquist, and today's episode is Litigation. What's the process and why does it seem to take so long? Jordan, great to see you again.
Always a pleasure to be here with you, Kevin. Thank you so much.
All right, so let's talk about the basics here. Let's talk about what litigation entails and how it differs from the idea of simply filing a claim.
Litigation just the most basic definition is when a claim gets converted into a lawsuit or a legal pleading. And so in every county, there's a courthouse, or in most counties, there's a courthouse where you go and you file what's called a complaint and a summons, and you serve it on the at-fault party. And that is the initiation of what we call the litigation process or filing a lawsuit.
We talked on last episode that only a small percentage, under 5% of your cases go to trial. What are the common reasons that a case would go to trial rather than being settled? Yeah,
good question. And I would say in our practice, really, the number is probably 1% to 2% that actually go to trial. And to be specific, trial is like where you've got the judge with, a 12-person jury here in Georgia, and they're listening to evidence and doing all those things. And there's an opening and closing. Most cases, even those that get filed in court with a lawsuit, don't actually get to go to trial. So the litigation process really is, once that lawsuit is filed, the process of getting to a jury trial. And that can take a long time. And again, in my practice, I would say 80% of our cases settle without having to be filed in court. And of those that are filed in court, 97% never go to trial.
Okay. Is it typically the defense is sort of the insurance company, whoever you're dealing with, does the right thing or is pressured or they know they don't have a case? Like what is their motivation to settle?
Yeah, good question. Risk. Both sides. What we do is risk assessment. What the insurance companies do is risk assessment. And so both sides, the main job of an attorney like myself who goes to trial, and the main job of an attorney on the other side who's defending, is to assess the risk. And as the evidence comes out, we go through this litigation process of discovery, of written questions, of depositions, of going and talking to witnesses and talking to doctors and the police officers and examining all the photos and the MRIs and the medical records, all those things. As you combine those things, the risk factor or the risk level either goes up or it goes down. And as it goes up, the insurance company, they tend to say, well, the risk gets too risky. The chances of us losing in court goes up, and it becomes more likely that the jury, once they get all the evidence, will make an award for the plaintiff that is uncomfortable for the insurance company. So they make the business decision really to say, hey, look, we'd rather not take that risk. We would rather just pay you now this amount and sort of buy our way out of this. That's basically what happens.
Are there situations where you'll recommend going to trial to a client because you feel that that's the best interest of them?
Yeah, all the time, actually. And the jury, the process of trial is really important in what we do. And in our firm in particular, we prepare every case as if we're going to trial. And we have to do that, because if we don't, then the insurance companies and their attorneys won't respect us. They'll say, Jordan will settle, or the Jewkes Firm attorneys, they're not serious. And that's not a reputation we have. It's not a reputation we want. We want the reputation that, hey, if you don't evaluate the case with a fair value, then we will go to trial. So absolutely, if the insurance company is not willing to pay a fair value on it, we will absolutely recommend that we go to trial.
Are there any situations where you feel pretty early that it's going to go to trial, or is it all a process?
Yeah, and we've talked about, every case is different. And so, there are some cases where we initially file and we say, the insurance adjuster that we've worked for has already told us they're never going to pay, and just to prepare for trial. What often happens is an attorney gets on board and defends it and starts to tell the insurance company, look, these facts aren't quite as good as you thought. Jewkes is going to be able to bring this on and present a good case, and we've got some real exposure there. And so even cases that I think are 99% going to go to trial based on what the insurance companies told us. Even a lot of those end up trying as well. And to be fair, sometimes our clients will say, hey, they're nervous about going to trial. And sometimes their expectations lower the closer we get because they start to recognize there's risk on their end, that maybe the jury won't give them a verdict that they're hoping for, so that they need to kind of get what they can to, be happy and move on their way.
Can you elaborate a bit on the discovery process and why? I think there's a reputation for discovery being something that takes a long time.
Yeah, and I would say the discovery process is certainly the longest portion of the litigation process. And again, the litigation is the time that you file the lawsuit to the time you and including the time you go to trial and until a jury gives you an award. That's sort of the litigation process. And discovery in Georgia is typically a 6-month period, at least 6-month period, where the parties are supposed to freely exchange information. Now, freely that can be tricky, but both sides are entitled to understand what may be presented by the other side as evidence in trial. And so in Georgia and in most states, we have the idea that no one should be surprised by what the other party has at trial. So discovery is when medical records are shared, medical bills, you have the opportunity to talk to doctors, witnesses, even the person who is injured, they should have to give their deposition. And so depending on the complexity of the case, depending on the scheduling of experts, depending on everyone's availability, usually we see discovery in a typical car wreck case take at least 6 months and very often longer into a year, because there's just often a lot to do. And sometimes you discover one piece of evidence and that leads necessarily to several other pieces of evidence that need to be discovered.
And what typically happens during the deposition? What kind of information comes out? What kind of questions are asked? What are the lawyers looking for here?
Yeah, great question. The deposition, again, is an integral part of that litigation process. And it's really an opportunity for everyone to tell their story. And I say tell because it's an oral process where you sit down, there's a court reporter who swears you, who has you give an oath that you'll tell the truth. And then usually the attorney from the other side, and so if we represented you, then the attorney from the insurance company would ask you questions under oath, and you're obligated to give honest and complete answers. And so we usually will talk to our clients, kind of prep them on the type of questions to expect. But our side is fairly easy on that regard because you just need to be honest and tell the truth. Mm-hmm. And then likewise, we do the same thing. We take depositions of the at-fault party, whether it's the driver or the employer or the safety manager, whoever it is, so that we can really find out what they may say at trial. And so at their core, a deposition is your sworn testimony under oath about what you may say at trial. And so it's really an important part of what we do.
And something to point out, I think, is that the settlements can still happen at any time, right? A case can settle at any point in the litigation process.
Oh, yeah, absolutely true. And again, 98% of the time it does happen. And we have some cases where we file a lawsuit and then an insurance attorney gets involved and it settles quickly. Yeah. And those are sometimes ones where they say, gosh, it's going to cost so much money to really take this case to trial. We just think it's in our best interest to settle it. There are some cases that settle after depositions, and that's probably fairly the most common, I would say, is once they get an opportunity to take our client's deposition and sort of go through the written discovery process, that's a fertile time for discovery. Because after that, then very often experts need to be involved if they're not involved at the beginning. And those experts will tend to get more expensive, and that's a cost. Those are costs that both sides have to incur. So typically, cases will resolve after the deposition is given.
Is that also kind of a chance for the defense attorneys to kind of gauge the victim and see oh man, this person would crush us at trial, or this person would be terrible at trial? Do they try to gauge the person too?
Yeah, you're hitting the nail on the head there. I mean, most insurance companies will sort of say, we want to take your client's deposition and then we'll consider settlement. And I guess there's nothing wrong with that unless it's just, it's a frivolous defense, as we say, or there's no reason that they need to do that. But yes, most insurance companies, one of the most important things they want to know about our clients is whether they're credible. And what I mean by that is whether a jury will like them. whether their statements are believable. Because unfortunately, there are people out there that are in this just to make a buck. And that's not right. It's not who we represent. But there are people like that. But the insurance company, I think, assumes that way more people are like that. That really almost every injured person is just there to have with a frivolous claim, which is really, really bogus. So yeah, they want to test the plaintiffs, the injured parties' credibility almost more than anything at a deposition.
Can you kind of talk about the process of litigation? So we've gone through the discovery, depositions. So what comes next, and how does it make its way to trial?
Yeah. So usually once you file a lawsuit, there's about a 30-day period of waiting. The other party has to file an answer or a response to the lawsuit. And then usually the 6-month period for discovery kicks in. And so by then you're already 7 to 8 months in it. And that can sort of be, kind of feel like time is dragging on. And sometimes at the close or near the close of discovery, the two sides will agree, well, we need more time, 3 months or 6 months. And sometimes that's repeated. And so the discovery period can be extended really as often as the judge will allow or the parties need. Generally speaking, you want to limit those, but you also don't want to, try a case with only one arm tied behind your back because you didn't allow for enough discovery. But yeah, that discovery period can take a year or so very often. But once the discovery period is ended, if there's experts that are needed, if there's witnesses that are being deposed, that's usually happened. And then the court will set what we call a trial calendar. And they'll say, hey, look, we have 10 cases like yours, on a civil calendar. And to be honest, Kevin, that in some courtrooms, that doesn't happen but 3 or 4 times a year. And sometimes you just don't get to the top of that list such that your case gets called. And so when clients sometimes get frustrated or impatient with the litigation process, it's very often just kind of out of the attorney's hands because there's a logjam at the top of the court docket or on the trial calendar. And you're literally just waiting for the court to give you a date to go in and have your trial.
All right. Can you talk about mediation and arbitration and how they're different and where they fit into the timeline of within litigation?
Yeah, absolutely. So mediation and arbitration are attempts to get third parties involved in the case to help settle the case. And I'll talk more about mediation because I think mediation is way more common and we see it in many of our cases. Mediation can be court ordered. In other words, it can be when the judge says, hey, you two go hire someone to hear your case and pay them to help you come to a number that resolves it. But it can also be voluntary. And sometimes voluntary mediation is when the attorneys for both sides get along. They may disagree with the value of the case, but they trust and recommend a mediator or a third party neutral that can come in who's got some experience that can say, hey, look, I recognize the facts from the plaintiff and I recognize the facts from the defense. I think this is generally where it needs to settle. And so mediation tends to be a good option if both parties are interested in being involved in it.
And does it tend to favor one or the other, or is it pretty neutral?
It can favor one side or the other, but I think in general, if both parties are playing fair and come with the hope and the expectation to resolve, the mediation is generally pretty neutral. I tell my clients, and I hear mediators say this all the time, which is a good mediation, right? An effective, successful mediation is when both parties leave with a deal, right? The case is being closed and both parties aren't super comfortable with the result. So in other words, it's a compromise. And so a good mediation, I think, is when the insurance company pays more than they want, but also the plaintiff takes less than what they expected.
And then with arbitration, how does that differ?
Arbitration is a little bit different because it can be a panel, but it's someone who makes a ruling in an informal, it's kind of like a panel or a tribunal. It's almost like a mini court where the parties go in and they present evidence in usually summarized manner. Sometimes it can be more lengthy. And there's usually one arbitrator who's kind of like a judge, not in the official capacity of the judge, but sort of in the private, hey, pay me to be your judge. And that judge, and sometimes there's 3 of them, they will come with a determination, a decision, and both the parties either are bound by that or they can walk away from it. So really the difference between arbitration and mediation is arbitration, there is a decision given, like it or not, this is what the result is. But in mediation, the mediator goes back and forth and tries to get the 2 parties to agree on one number.
And if they can't agree in mediation, then they might still go to trial. Whereas in arbitration, it's done, right? Is there a recourse after it if the plaintiff still doesn't like what the arbitrator did?
Yeah. So mediation is almost always voluntary. And if you don't if you don't come to an agreement, you can walk away and proceed to trial. And with arbitration, there's a lot of variance. Some arbitration is considered binding and you've got to accept what was given. But most of the time arbitration is, hey, here's what someone, determined after listening to all the evidence. You can either take it or ignore it at your own risk. But with most decisions, you can walk away with both and still pursue trial if that's really what you want to do.
So throughout the litigation process, what role does the judge play? Is the judge an active part or only kind of addressed when needed? How does a judge kind of fit in?
Yeah, so great question, Kevin. And the judge plays kind of the role of a gatekeeper up into trial. And then even at trial, they're kind of a gatekeeper. But the judge kind of becomes the king in the arena. And when the parties aren't playing fair in the arena, they can look to the judge and say, Judge, there was a foul there. King, there was a foul there. Can you tell that other person that they have to play nice? And in most cases, to be honest, we have good relationships with the defense attorneys. Both parties know the law, they know the rules, and they don't need to appeal to the judge prior to trial. But the judge sets the deadlines. They tell the parties to play fair, and the judges are great. They'll say, hey, we can be available if you need to have a conference or something. But when the judge says, hey, this is the law of the land, when they say jump, you have to say how high. And so we respect the judges. We love the judges, and they do a great job.
It's like you said, respecting the king, right?
That's exactly right.
All right. Well, thanks for joining us on Peachtree Injury Talk with Jordan Jewkes. To connect with Jordan and his team, visit jewkesfirm.com. And please like and subscribe to our channel and leave us a review. Jordan, always great talking with you. Thanks so much.
Likewise. Thanks, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.